The Supreme Court of India in Shailendra Mani Tripathi versus Union of India case has clearly stated that compulsory menstrual leave cannot be mandated by the court. In fact, it also stated very clearly that if the court directs for a compulsory menstrual leave, it would lead to the problem of women being recruited less in the private sector jobs. Primarily because it will create a stereotype among the companies that women workforce are a burden primarily because of excessive leaves. Then over and above that, it will also in fact reinforce the gender specific norms which are present in society, which consider women to be physically weak and not equal to that of men. Because of these factors, the Supreme Court has clearly stated that the court is in no position in order to mandate a compulsory menstrual leave. But many states across India and some private organizations also across India on a voluntary basis have already provided for menstrual leave. And there should be some serious negotiation and debate which should happen between the stakeholders and the government at the highest level, and that can only happen through Parliament and the executive. But the Supreme Court, if it gives such kind of order as a fiat, it would be considered as definitely interference into the private sector's working. Then over and above that, even when there was a discussion with respect to maternity leave in India also, in the Indian Parliament, it has been stated that 6 months of paid maternity leave is going to create disincentives for women workforce. But we have seen and observed clearly that it enhanced the social welfare without limiting the opportunities which are available to women, as we can clearly see that the women workforce participation rate, particularly in the white-collar jobs, post-maternal leave have increased. Because of these factors, it is necessary for us to also have a serious discussion about the menstrual leave, and based on wide stakeholder consultation, we should come to a decision. Thank you.